I bought the farm next to the HOA because it had the one thing they needed most: water. Their whole development ran on a spring-fed reservoir tucked against my eastern boundary, and for 22 years nobody had bothered to record a single legal right to it. The county approved the system. The board assumed the paperwork existed. It didn't. I found the intake pipe on my first walk of the property. 4-inch PVC, cleanly cut through the berm, crossing my fence line and pulling from my reservoir into their subdivision like it had always belonged there. It hadn't. The land was mine. The water permit was mine. And the only thing they had was a notebook paper note from the original owner saying they could run the pipe, as long as he had no trouble. Then the HOA sent me a letter demanding I fence my cattle away from their community access path. That was the moment I realized they had mistaken permission for ownership. So I sent them a notice of unauthorized water access. As we get started, I'm curious, where are you watching from? Drop your location in the comments. And if you're excited, go ahead and like and subscribe. Walt Greer had farmed the 3,200 acres for 41 years before his knees and his balance sheet made the decision for him. He had run cattle on the lower pastures, dry-farmed wheat on the upper flats, and managed a spring-fed reservoir on the eastern boundary that had been the farm's water backbone since his father sank the first collection pipe in 1958. The spring came out of the limestone shelf at the base of the eastern ridge. Not dramatic, not visible from the road, just a steady, reliable seep of cold water that had filled the reservoir through every dry summer Walt could remember and had never once let him down. He sold the farm in 2006 to a crop operation out of the next county that ran it for 8 years and then sold it again to a land investment group that held it without farming it for another 6. By the time Caleb Marsh saw the listing in the spring of 2024, the farm had been through 2 owners since Walt, and neither of them had paid attention to what the eastern boundary was doing. Caleb paid attention to everything. He had left this county at 22, the year his father's farm went to the bank. Not Walt's farm. A smaller operation 12 miles north that his father had borrowed against twice too many times in 2 bad harvest years and had lost before Caleb was old enough to do anything about it. He had driven out of the county with 2 boxes of clothes and a specific, durable understanding of what land meant when you stopped owning it. He had spent 26 years in agricultural land management after that. Not farming, managing. Acquiring undervalued parcels for investment groups, assessing operational potential, overseeing improvements, negotiating water rights and access easements and soil restoration contracts. He had worked in 3 states and had become the kind of professional who could read a parcel's productive potential from a topographic map and a soil survey and a county water board filing before he ever set foot on the ground. He had looked at hundreds of farms. He had come back to this county for this one because the land was undervalued in the way that land is undervalued when its recent owners have not farmed it, and its listing price reflects the absence of active use rather than the presence of productive potential. The lower pastures were overgrown but not damaged. The upper flats were rested. The spring-fed reservoir on the eastern boundary was full and clean and fed by a water permit that dated to 1962. He made the offer in April. He closed in May. The farm was his. He spent the first 6 weeks doing what he always did with a new acquisition, walking it. Not inspecting, walking. The difference mattered to him. Inspecting was clipboard work, systematic, looking for specific things in specific places. Walking was something else, moving through the land at the pace the land set, paying attention to what the land showed rather than what the checklist required. He had done it on every parcel he had managed for 26 years and had found things on those walks that no inspection had flagged, because inspections looked for what was expected and the land occasionally showed you what was not. He walked the lower pastures first, then the upper flats, then the eastern boundary where the reservoir sat behind a low earthen berm his father's generation would have recognized as functional and competent. Nothing fancy, built to hold water rather than impress anyone. The spring came in from the limestone shelf on the north side of the berm, cold and steady, the way it had apparently always come in. He walked the intake structure on the reservoir's south face. He stopped. There was a pipe, 4-inch PVC, running from the reservoir's lower drainage point eastward through the berm and continuing beyond the farm's boundary fence into the ground on the other side. Someone had cut through the berm, set the pipe, and backfilled around it. The work was clean and professional, Not a recent improvisation, but something that had been in the ground for years. The pipe had a valve on the farm side of the fence, currently open, and a meter housing on the far side that had the look of utility infrastructure. He crouched next to the valve and looked at the pipe. Then he looked at the fence line. The boundary fence was his. The pipe crossed it. The pipe was drawing water from his reservoir. He did not touch the valve. He took photographs of the intake structure, the pipe, the meter housing, and the fence crossing. He noted the GPS coordinates. He went back to the farmhouse and called Ellen Marsh. Ellen was 52, a title and water rights attorney who had practiced in the region for 24 years. She was not related to Caleb. The shared surname was coincidence, but he had used her on 2 prior acquisitions and trusted her work. She was thorough in the way that good title attorneys are thorough, not fast, not dramatic, but complete. She did not tell clients what they wanted to hear. She told them what the records showed. He described the intake pipe and emailed her the photographs. She said, "I'll pull everything. Give me a week." She pulled the title chain going back to 1952. She pulled every recorded easement, every utility right-of-way, every water access agreement on the parcel. She pulled the county's utility infrastructure records for the adjacent development, Creekside Pines, a 340-household subdivision that had been developed on the land east of the farm boundary in 1998 and 1999. She pulled the State Water Board records for permit number 4471, the farm's appurtenant water right covering 340 acre-feet per year from the spring. She also pulled the HOA's recorded governing documents, their utility service agreements, and the county's water system registration for the development. It took her 9 days. The fence line letter from Diane Pruitt arrived on day 7. It was on Creekside Pines Community Association letterhead, 2 pages, signed by Diane Pruitt, board president. It stated that Caleb's cattle had been observed in the corridor along the development's western boundary, a strip of land Diane characterized as a community pedestrian access path that residents had used for recreational access to the adjacent farmland for over 15 years. It demanded that Caleb fence his cattle away from the corridor, install signage acknowledging the access path, and respond in writing within 30 days or face legal action to establish the access right through a prescriptive easement claim. Caleb read the letter twice. He had grazed 24 cattle in the lower pasture's western section for 3 weeks. The corridor Diane described was a strip of his own land. He had walked it. He had the survey. He knew the boundary. Residents had apparently been walking across it for years under the assumption that it was common area or public access. It was neither. It was a private farm parcel that the previous owners had not actively managed and had therefore not posted or fenced against casual use. The letter was the kind of thing a new landowner received when a development had gotten comfortable treating adjacent land as an extension of its amenities. Caleb had seen versions of it before. It was a nuisance, manageable, the sort of thing a firm response letter from Ellen would resolve in 2 rounds of correspondence. He forwarded the letter to Ellen with a short note. "Add this to the file." 2 days later, she called him. He was in the upper flat doing a soil assessment when the phone rang. He took it standing in the field with the survey map on the hood of his truck and the afternoon coming in flat and golden across the grain stubble. Ellen said, "I've finished the title review. I need to walk you through what I found before you respond to the fence line letter." He said, "How bad is it?" She said, "It's not bad for you. It's complicated for them." She walked him through the title chain first. Clean transfer through 3 owners. No recorded easements for water access on the eastern boundary. No utility right-of-way for the intake pipe. No recorded license agreement. No mention in any recorded instrument of any obligation to supply water to the adjacent development. Then she walked him through the water permit. Permit number 4471. 340 acre-feet per year. Appurtenant to the farm parcel. Transferred to Caleb at closing as part of the real property. The permit covered the spring and its tributary groundwater. It was his. Then she said, "The intake pipe you photographed is the primary water supply for Creekside Pines. The development has no municipal water connection. Their entire system runs off the reservoir draw. I pulled their water system registration with the county. It identifies the source as the spring-fed reservoir on the adjacent agricultural parcel. There is no easement recorded against your title authorizing that draw. There is no recorded license agreement. There is no water access agreement of any kind in the county recorder's records between the previous farm owners and the HOA or its predecessor developer. Caleb was quiet for a moment. He said, "How long have they been using it?" Ellen said, 22 years. The intake pipe was installed during the development's construction phase in 1999. The system has been drawing from your reservoir since then. He said, "And they have a recorded right to do that?" Ellen said, "Nothing. Not a line." He stood in the upper flat with the survey map on the truck hood in the afternoon going quiet around him and looked east toward the ridge where the spring came out of the limestone shelf and ran into the reservoir and had been running into the reservoir since 1958 and had apparently been running into the pipes of the adjacent development for 22 years without anyone ever recording a single instrument to make that arrangement legal. He said, "Send me everything you have." She said, "It's already in your inbox." He ended the call and looked east for a long moment. Then he got back in the truck and drove toward the reservoir. The spring was running the way it always ran, steady, cold, indifferent to who owned the land around it, or who had been drawing from it, or who had been sending fence-line demand letters to the man who now held the title and the permit and the right to decide what happened next. He drove to the reservoir and sat by the berm until the light went. He had a lot to think about. The water system at Creekside Pines had always looked like other HOA water systems. Functional, unremarkable, the kind of thing that only became noticeable when it stopped working. The developer, a now-dissolved entity called Ridgeview Communities, had built the subdivision in 1998 and 1999 on a 180-acre plat just east of Walt Greer's 200-acre farm. The county had approved the plat with the explicit understanding that the development would not connect to the municipal water system because the infrastructure was too far away and the cost too high. Ridgeview had proposed and obtained approval for a private water system, a spring-fed reservoir sourcing its supply from the spring on the adjacent agricultural parcel, with a 16-inch distribution main looping through the development's interior streets and branch lines to each lot. The county had signed off on the design because the spring had a documented history of reliable flow and the reservoir had sufficient capacity to serve 340 households. What the county had not required, and what Ridgeview had never bothered to create, was a formal, recorded easement granting the development access to the spring or the reservoir. The county's review had focused on the system's design, not the underlying land rights. Ridgeview had relied on Walt Greer's informal willingness to let them use the water as long as we're neighbors and it don't cause me trouble. That had been enough for the builder, the county, and the eventual HOA because the water kept flowing. Walt had written the arrangement down once, not on a formal document, not on a notarized agreement, but on a piece of notebook paper. The letter was dated April 12, 1999. It read, in Walt's uneven cursive, Ridgeview Communities. You may use the spring water for the subdivision so long as we're neighbors and it don't cause me trouble. No fee, no paperwork. Just run the pipe and keep the land tidy when you're in it. Walt Greer. The developer had filed a copy in its project file. The HOA had inherited that file after Ridgeview dissolved, and the letter had sat in an unlabeled box in the management office storeroom for 22 years. No one had ever framed it. No one had ever recorded it. And no one had ever asked the simple question, does this protect the development forever? Frank Solis, the HOA's treasurer, had asked the question twice. The first time was in 2006, shortly after Walt sold the farm and the new owner, the crop operation, took over. Frank had been on the board for 4 years and had spent the first 3 ignoring the oddity of the situation because the water had always worked. In 2006, when the farm changed hands, he had pulled the county records and discovered nothing acknowledging the development's use of the spring. He had brought it up at a board meeting and Diane had told him it was handled. The developer had made it all official, and the county had approved the system, so it must be legal. The board had voted to table the issue. The second time was in 2014, when the Land Investment Group took ownership. Frank had done the same check again. He had found the same blank result. He had raised the issue again. Diane, then in her second term as president, had told him he was overthinking it. The water had never stopped. The farm owners had never asked for anything. The arrangement was stable. The board had voted again to treat it as an administrative item, not a legal one. Frank had written his own private note in the HOA's internal archive. Water access. No recorded easement. See 1999 Ridgeview file if issue ever arises. He had never expected it to arise. Caleb did not know any of that when he first read Ellen's summary of the records. He knew only the raw facts. The intake pipe crossed his boundary. The reservoir was his under an unbroken chain of title. The water permit was his, and no recorded instrument anywhere in the county's records granted the HOA a right to do what they had been doing for 22 years. Ellen's research had turned up the 1999 system registration, the county's approval of the private water system, and the absence of any easement against the farm parcel. It had also turned up the dissolution records for Ridgeview Communities, which made the developer's vanished status obvious. Ellen's legal analysis was direct. The HOA had open, continuous, and habitual use of the water, but use alone did not create a permanent right. Without a recorded easement, without a recorded license, without a written agreement that had ever been attached to the title, the HOA's claim to the spring rested on custom, not law. The arrangement had been permissive, created by Walt's notebook paper permission, not by any recorded grant. Permissive use could not ripen into a prescriptive easement. The HOA was not in the clear just because the water had never stopped. Caleb walked with that for a day. He had a fence line dispute letter from Diane demanding he fence his cattle away from a corridor of his own land. He had a water system that had been drawing from his reservoir for 22 years on the strength of something that was not a line in the county records. He had the title, the permit, and the intake pipe. He had the position of the party whose land everyone had been using without formally asking. He called Ellen back on the second afternoon. He said, "Draft a letter." She said, "To whom?" He said, "Diane Pruitt, and the HOA attorney of record. I want to know what they think they own before I tell them what they don't." Ellen's letter was precise and unsparing. It began by stating the relevant facts: the farm's chain of title, the absence of any recorded easement or license on the eastern boundary, the state water permit appurtenant to the parcel, and the intake pipe's location on Caleb's land. It then stated that the HOA's use of the spring-fed reservoir as the source of the development's water supply appeared to be ongoing, but appeared to rest on no recorded legal instrument. It requested that the HOA identify any recorded easement, recorded license, or recorded agreement granting it the right to access, divert, or store water from the reservoir, or to operate the intake pipe on Caleb's land. It ended with a simple sentence: if the HOA cannot provide a copy of any such recorded instrument, Mr. Marsh will assume that no such instrument exists and will treat the HOA's use of the reservoir as unauthorized, effective immediately. Caleb read it twice and signed it. Ellen had it sent by certified mail and electronic notification on a Monday afternoon. The HOA received it on Tuesday morning. Diane was at her dining room table with her laptop, drafting her second follow-up letter to Caleb about the fence line corridor, insisting that the HOA had an established right of access, threatening to initiate a prescriptive easement claim, and suggesting that Caleb had a responsibility to be a good neighbor. When the email notification arrived, the subject line read, "Formal notice of unauthorized water access. Caleb Marsh to Creekside Pines Community Association." The tone of the title made it clear this was not the same kind of letter. She opened it in the same window she had been using to draft the fence line email and read it to the end. Then she read it again. Then she picked up her phone and called Frank Solis. Her voice was tight when he answered. She said, "Frank, get the Ridgeview file. I need to see what Walt signed." Frank said, "I already know what it is." Diane said, "What?" He said, "A piece of notebook paper. You may use the spring water, so long as we're neighbors and it don't cause me trouble. No fee, no date on an easement, no line in the county records. We don't have a recorded right. Not one." Diane was silent for a moment. Then she said, "He's saying he can shut off our water?" Frank said, "He's saying he can treat our use as unauthorized. There's a difference. But legally, he's in the stronger position. We never recorded anything. The permit's his name. The land's his name. The pipe's on his land. The only thing not his name is the word neighbor in Walt's handwriting." Diane said, "And you never told me this?" Frank said, "I did. Twice. You said it was handled. The board said it was handled. We never recorded anything because no one wanted to pay the notary or the recording fee, and everyone thought the developer had taken care of it." The line went quiet again. Then Diane said, "Draft a response." I need to send something today. Frank said, before you do, read the letter again. He's not escalating about the fence. He's escalating about the water. That changes everything. She hung up without answering. She sat at the dining room table with Caleb's letter open on her screen and the unfinished fence line email still blinking in the next window. The two documents pulled against each other in a way that made the conflict suddenly asymmetrical. She had been writing to him as if the land around his farm was something subordinate to the development's needs. Now the land was the only thing holding back the development from losing its water supply. She closed the fence line email and started a new one. She did not finish it that morning. She did not send it that day. She spent the afternoon pulling the same records Ellen had already pulled, hoping to find something she had missed. She found the same blank result. By evening, she had two realities in front of her. The letter she had written telling Caleb to be a good neighbor, and the letter he had sent saying he owned the spring that her community had been drinking from for 22 years with no recorded right at all. The reservoir ran through the eastern boundary the way it always had. The conflict had just changed direction. Diane called the special board meeting the same day. She read Caleb's notice letter. She didn't schedule it for the next week. She didn't leave it for a routine board gathering. She assigned it to the following evening and sent an email to all 340 households before she even told the rest of the board, framing it as an urgent water system update. The wording was calm, but the timing was urgent enough that residents knew something was wrong before anyone explained what. The meeting was in the Creekside Pines Community Center, a boxy building near the development's eastern entrance where the pipe from the reservoir ran under the road into the main distribution line. The room was full an hour before the official start time. People sat in folding chairs, stood along the back wall, or watched the live stream from the community app. Frank arrived at 6:05 and found Diane already at the front table, laptop open, the printouts of Caleb's letter stacked beside her. She opened with a statement. She said the HOA had received a formal letter from the new owner of the adjacent 200-acre farm about the water system. She said the HOA had always operated under the assumption that the arrangement allowing the development to draw from the spring-fed reservoir was secure and long-standing. She said the letter suggested that the arrangement might not be recorded and might not be binding on the new owner. She said the board was taking this seriously and that legal counsel was reviewing the matter. She did not say the HOA had no recorded right. She did not say the HOA had been relying on a piece of notebook paper. She did not say Caleb could, in fact, treat the HOA's use as unauthorized. She said the HOA's attorneys were reviewing the history of the water access and that the board would seek a permanent resolution that protects the community's needs. People asked questions faster than she could answer them. Is our water going to be cut off? Can he actually do that? What happens if he does? Diane said she did not know yet. She said the HOA was engaging a water rights attorney immediately. She said the board would schedule a follow-up meeting once the attorney had completed their review. By the end of the hour, the room was tense and the forum was already on fire. The forum was officially called Creekside Pines Community Hub, and unofficially, it was where the HOA's internal politics bled into the open. By 7:45 p.m., the topic, Water Letter from Caleb, had 127 posts. The first thread was someone who had screenshot Diane's email about the urgent water system update and asked what it meant. The second was a resident who had seen the subject line of the formal notice in Diane's opening statement and had copied the text of the water rights language in their own post. The third was someone asking, "Wait, are we saying the guy who bought the farm next door owns our water?" Frank did not post anything. He sat in his living room with his laptop open, the same way he had sat through two prior quiet crises, and read every post. He did not respond to the panicked ones. He did not argue with the people who said the HOA had always done this, or it's just a formality. He did not correct the ones who said the developer took care of it because he already knew that phrase was the source of the problem. He just read and watched the fear build in the digital thread the way it had built in the room. The rest of the board posted occasionally, one member insisting the HOA's use was long established, another saying the county had approved the system, a third asking whether anyone had actually seen the notebook paper letter. Diane commented once, late in the evening, saying the HOA's attorney was analyzing the situation carefully and that residents would be updated as soon as we have concrete information. She did not say the attorney had not yet been retained. The HOA hired the attorney the next morning. Diane had called 2 firms the night before and had chosen the one that specialized in water rights and utility disputes. The attorney, a man named Robert Nasir, reviewed the HOA's records package over the course of Thursday and Friday. He looked at the 1998 plat, the 1999 system registration, the dissolution records for Ridgeview Communities, the county's approval of the private water system, and the HOA's internal archive. He looked at Walt's notebook paper letter, the 2006 and 2014 internal notes Frank had filed, and the absence of any recorded easement on the farm's title. On Friday afternoon, he called Diane. He did not soften it. He said the HOA had been using the reservoir for 22 years, but the HOA's right to do so was not protected by any recorded instrument. He said the arrangement had been permissive, created by Walt's handwritten permission and never formalized. He said permissive use could not ripen into a prescriptive easement. He said the farm's title ran clean. He said the water permit was Caleb's. He said the intake pipe was on Caleb's land. He said the HOA's best argument was equity, the idea that the community had built its entire water system on the reasonable expectation of continued access. But equity was not a title record and could not override Caleb's ability to treat the HOA's use as unauthorized if he chose to do so. Diane said, "So he can cut us off." Robert said, "Legally, he can. The practical question is whether he will. The leverage is entirely on his side. If he chooses to force a recorded easement or a compensation agreement, we can't block that. We can only negotiate." Diane said, "And if he doesn't negotiate?" Robert said, "Then he could shut off or severely restrict the intake. Your system is designed to rely on that spring-fed reservoir. You don't have a municipal backup, and you don't have a recorded alternative source. If the pipe stops flowing, your options are limited and your costs would be high." There was a silence on the line. Then Diane said, "Draft a response to his letter. Tell him we want to work this out." Robert said, "I'll do that. But I'm also going to tell him we're prepared to litigate the depth of the community's reliance on the spring. That's our only card. Just be clear with the board. We're playing defense here, not offense." She ended the call and stared at her laptop. She had written the fence line letter to Caleb under the assumption that the HOA held the stronger position. Now she was drafting a new letter under the assumption that the HOA held the weaker one. The water that had seemed like a background fact of life had become the central fact of the dispute, and the man who had just bought the farm next door had become the only person in the county who could decide whether the development kept drinking from it. She opened the letter draft and stared at the blank page. Her first sentence took 3 tries. "This letter is in response to your notice of unauthorized water access dated." She stopped. The words unauthorized water access felt more dangerous now than they had when she first read them. They no longer sounded like a legal phrase. They sounded like a warning. She finished the sentence. "And we wish to propose a negotiated resolution that preserves the community's water supply while respecting your property rights." The community was watching. The forum was still running. Frank was still reading. The reservoir ran on the other side of the fence under the same limestone shelf where the spring had come out every day for 68 years. The letter went out Monday. Caleb received it the same day he received the first drought condition notice from the county water board. The stakes had shifted. Discovery started where it always started, with documents. Ellen Marsh had already pulled the recorded records. What she needed now were the internal ones, the HOA's own files, the HOA's own memories, and the HOA's own internal acknowledgement that the water arrangement had never been formalized. She issued a full document request to the HOA's council, asking for every board packet, every management file, every note, every piece of correspondence related to the spring-fed reservoir, the intake pipe, the notebook paper letter, and any prior discussions about water access. She also requested a list of every person who had ever been involved in those discussions, including Gary Pruitt and Frank Solis. The HOA produced the documents reluctantly. They came in boxes and PDFs over 3 weeks. Ellen sorted them into categories: system operation records, board minutes, internal notes, correspondence with the developer, and a Ridgeview file. The notebook paper letter was there, exactly where Frank had told Diane it was, loose in a folder labeled Water Arrangements, with no date stamp and no cross-reference to the county recorder's index. The first key revelation came from the board minutes. In 2006, Shortly after the farm changed hands for the first time, Frank had raised the water issue in writing. The entry read, "Treasurer reminded board there is no recorded easement on file for the spring water intake. Asked whether the HOA should pursue recorded access. Board voted to table topic pending further review." In 2014, when the Land Investment Group took over, he did it again. Treasurer noted again absence of recorded easement. Suggested the board consider recording an access agreement. Proposal discussed but tabled. The board had never recorded anything. The issue had been acknowledged internally and then set aside. Gary Pruitt's name surfaced in the Ridgeview file along with a notebook paper letter. The file contained a brief summary of the 1999 arrangement. Developer coordinated with Walt Greer to allow use of spring water for subdivision. Agreement in writing on notebook paper dated April 12, 1999. No formal easement prepared at this time. County accepted system registration based on spring source and reservoir capacity. HOA will inherit access rights with developer's dissolution. The phrase access rights was not a legal term. It was an assumption. The county had accepted the system registration based on the spring source and the reservoir capacity, not based on a recorded easement. The file also contained a note that Gary had driven out to Walt's place with the developer's engineer to confirm the spring's reliability and had come back with Walt's permission to run the pipe, as long as it didn't cause him trouble. The HOA's position that the water arrangement was handled was not a legal position. It was a memory. Frank's deposition came first. Ellen had asked for it specifically. She had read the board minutes, the internal notes, and the 2006 and 2014 entries. She knew Frank had been the only member of the board who had consistently pointed out the lack of a recorded easement. She also knew he had been the only one treated as if he were overthinking it. His deposition was therefore potentially the most damaging to the HOA's argument that the use had been open, notorious, continuous, and hostile for prescriptive easement purposes, because he had been the one documenting its permissive character all along. The deposition was held in a conference room at the HOA's management office. Frank sat at the table with his attorney, Robert Nasir, on video, and Ellen across from him with her notepad and her laptop. The camera was off, the transcript was on, and the room was quiet. Ellen started with the basics. Question: Mr. Solis, you have been a member of the Creekside Pines Community Association Board of Directors since 2002? A. Yes. Question: and you have served as treasurer throughout that time? A. Yes. Then she moved to the water. Question: have you ever reviewed the county recorder's records to determine whether there is a recorded easement granting the HOA the right to use the spring-fed reservoir on the adjacent 200-acre farm? A. Yes. I have done that twice, once in 2006 and once in 2014. Question: and what did you find? A. Nothing. No recorded easement. No recorded license. No recorded agreement. The access to the water appeared to be based on the arrangement made with the former farm owner, Walt Greer. Question: did you bring that fact to the attention of the board? A. Yes. I did so in both 2006 and 2014. I suggested the HOA might need to formalize the arrangement or at least record an easement. The board chose to table the issue both times. Question: why did you decide to raise it again after the change in ownership in 2014? A. Because the farm changed hands again, and the new owner was not the same person who had originally agreed to allow the use. The informal arrangement had lasted under Walt, but it wasn't clear that it would transfer to anyone else. The board's assumption was that it did. My assumption was we should make sure. Question: did anyone at the board level challenge that assumption? A. The president at the time, Diane Pruitt, told me it was handled and that the county had approved the system, so the access must be valid. The board voted to allow the issue to remain open but not to take action. I notes in the internal archive that we had no recorded easement. That's in the file. Ellen stopped there and moved to the prescriptive easement question. Question: do you understand that the HOA has argued that its use of the spring-fed reservoir and the intake pipe on the farm's land constitutes an open, notorious, continuous, and hostile use sufficient to establish a prescriptive easement? A. I've heard that, but I don't agree with it. Question: why not? A. Because the use was never hostile. It was allowed by Walt. He wrote a note saying the developer could use the spring water as long as they were neighbors and it didn't cause him trouble. That's permission. Hostile use means someone is using your land without your permission. This was the opposite of that. Question: did you communicate that understanding to the board at any point? A. I did. Not in those exact words. But I said it was an informal arrangement with the prior owner and that it wasn't recorded. The board's understanding was different. They believed Walt's permission was enough and that the county's approval of the system made it permanent. Ellen moved on without emphasizing the point. She didn't need to. The transcript was building the argument for her. The HOA had always known the arrangement was informal. The HOA had never recorded it, and the HOA had assumed it transferred anyway. The permissive use element was now on the record in the voice of the board's own treasurer. Gary's deposition came next. Gary Pruitt was 58, had served on the HOA's architectural committee since 2001, and had been present at the original 1999 arrangement. He had driven out to Walt's place with the developer's engineer and had watched Walt write the notebook paper letter. He had seen Walt say, "Run the pipe and keep the land tidy." He had understood then, and he understood now, that the HOA's use of the spring was based on that handwritten permission, not on any recorded instrument. Ellen began with the 1999 meeting. Question: Mr. Pruitt, in 1999, you met with Walt Greer concerning the developer's intention to tap into the spring-fed reservoir on his farm. Is that correct? A. That's right. The developer wanted to install the intake and run the pipe. They came out to the farm to see if Walt was willing. Question: and what was the result of that meeting? A. Walt agreed to let them use the spring water for the subdivision. He wrote that note on notebook paper. He said they could use it as long as they were neighbors and it didn't cause him trouble. Question: did he mention any fee? A. No. He said there'd be no fee, just that they keep the land tidy when they were in it. Question: was there any discussion of a formal easement? A. No. The developer's engineer said they'd handle it with Walt's permission. Walt didn't want to pay the recording fee or deal with notaries. The county accepted the system registration, and everyone assumed that was enough. Question: so the county's acceptance of the system registration was treated as if it created a legal right? A. In practical terms, that's how it was treated. The developer said the water access was approved. The county wasn't asking about the land records. They were approving the system design. The landside question never got answered. Ellen paused. She had what she needed. The prescriptive easement argument was done. Permissive use could not become a prescriptive easement. The developer had operated on the assumption that Walt's permission was enough. The HOA had operated on the same assumption for 22 years. The county had never required a recorded easement. The board had never created one. The only thing that had changed was the owner's name. She asked one final question. Question: Mr. Pruitt, do you now understand that the HOA has no recorded right to continue using the spring-fed reservoir and the intake pipe on Mr. Marsh's land? A. Yes. Question: and the only basis for the HOA's use is the informal arrangement with Walt Greer and the continued use under the assumption that it was permanent? A. That's correct. She ended the deposition. The notebook paper letter itself was the final piece. Ellen had requested all copies of Walt's letter, and the HOA produced 3, the copy in the Ridgeview file, the copy in the HOA's internal archive, and a third that had been hand-scanned years ago and stored in the community's digital archive. The HOA had never framed it, never recorded it, never relied on it in any way that made the arrangement legally binding on future owners. The letter was essentially a memorandum of permission. You may use the spring water for the subdivision so long as we're neighbors and it don't cause me trouble. Ellen used it in her motion for summary judgment. She argued that the HOA's use of the reservoir and the intake pipe had been continuous, but it had been permissive, not hostile. She tied the letter to the board minutes, the internal notes, and the depositions of Frank and Gary. The developer's permission had never been recorded. The HOA had never recorded it. The farm had never recorded it. The permit had never been amended to reflect the HOA's use. The HOA could not claim a prescriptive easement built on permissive use. The HOA could not claim a right derived from an arrangement that had never been formalized. The HOA's legal position disintegrated from the inside out, not because Ellen was unusually clever, but because the HOA had built 22 years of reliance on a piece of notebook paper and had never once turned it into a line in the county records. The prescriptive easement theory collapsed. The board had no recorded right. The farm was Caleb's. The spring ran through his land. The intake pipe crossed his fence. The HOA's only option was negotiation. The community received the update through the board packet. Frank read it in the kitchen with his wife and said nothing. The forum lit up with new threads. The board voted unanimously to authorize settlement talks. The leverage was no longer a question. Settlement came quietly, the way most HOA disputes end when the record is as clear as the HOAs had just become. The board voted to authorize mediation. Diane still wanted to save face, but the subtext of the vote was written in the margins. The HOA's only viable path now was to negotiate a recorded water access easement on terms that Caleb would accept. The leverage had shifted fully. The spring ran through his land. The pipe crossed his fence. The permit was in his name. And the HOA's internal records confirmed that everyone had always known the arrangement was informal. The board could litigate, but the expected outcome was not in doubt. The mediation was held in a county conference room on a Thursday morning. Caleb sat with Ellen, the HOA with Robert Nasir and Diane, and the mediator in a neutral chair between them. The opening statements were brief. The HOA admitted the absence of a recorded easement and the permissive character of the 1999 arrangement. Caleb's side admitted the HOA's 22 years of reliance and the disruption that shutting off the intake would cause. The mediator framed the day's work, not a question of legal right, but of fair compensation and clear terms. The settlement that emerged was, in essence, the recognition of what had always been true. The HOA needed the water, and Caleb was the only one who could provide it. The HOA paid for the easement. The agreed-upon structure was simple. The HOA would pay Caleb a one-time consideration of $95,000, roughly the amount the county had estimated it would cost to install and operate an alternative water source for the development if the spring connection were lost. The fee was to be recorded in the county as the consideration for the easement. The HOA agreed to annual maintenance payments of $8,500 going forward, covering inspection, vegetation control, and routine maintenance at the intake site and on the portion of the pipe that lay on Caleb's land. The HOA would also bear the cost of any valve or meter upgrades required by Caleb's farming operations or by the county's environmental standards. The recorded document was a 12-page water access and conservation easement agreement. It granted the HOA a pertinent easement to access, maintain, and operate the intake pipe and associated infrastructure on Caleb's land for the purpose of drawing water from the spring-fed reservoir. It defined the spring and the reservoir as the sole source of the HOA's water supply, with the HOA agreeing that any future expansion of the development would require prior approval from Caleb, the county, and the State Water Board. It included a drought priority clause stating that in years where the county declared a drought condition, Caleb would have the right to reduce or temporarily suspend the HOA's draw from the reservoir to protect the farm's essential agricultural uses, subject to written notice 30 days in advance. The HOA accepted the clause because the spring had run low during a severe drought in 2012, and the board remembered that summer clearly enough to know the trade-off had to be formalized. The fee schedule was straightforward. The $95,000 paid at signing, with the annual $8,500 starting the following year. The HOA's board allocated the one-time fee from its reserve fund and the annual payment from its operating budget. The vote was unanimous. The easement was recorded with the county the following week. The intake pipe remained in the ground. The spring kept flowing. The reservoir kept filling. The development kept drinking. The fence line dispute ended the same way it had begun, in paper. The HOA withdrew its demand letter. The proposed prescriptive easement claim for the western corridor was abandoned with prejudice. Diane's second draft, the one she had started after reading Caleb's water letter, was set aside. The board approved a short resolution stating that the HOA acknowledged the 200-acre farm as private property and accepted that the agricultural use of the parcels along the western boundary would be managed by the landowner. The corridor was effectively rescinded as a community path, though the HOA did not require fencing. It simply stopped treating the land as anything other than what it was, a farm. Caleb did not put up a fence. He did not need to. The cattle stayed where he put them, and the residents stopped walking across the corridor once they realized the HOA had no legal basis to demand access. The few who had used it as a shortcut drifted elsewhere, to the paved walking paths, to the Central Park, to the established trails that the HOA had actually built and maintained. The corridor became a pasture again. Caleb farmed his land the way he had always planned to do. The lower pastures got plowed, planted, and rotated with a mix of winter forage and summer cover crops. The upper flats, after a year of deep tillage and soil remediation, went into a rotation of wheat, barley, and fallow. The spring's steady flow fed the irrigation system he installed, drip lines to the orchard blocks, pivot systems to the fields, and a secondary tank at the eastern boundary feeding the farm's own water needs. The intake pipe for the HOA remained in its place, now a visible line in the record, not an invisible assumption. When he walked by the reservoir, he could see the meter housing, the locked valve, the sign the HOA had agreed to install. Creekside Pines water intake, operated under easement. The spring itself did not care. It came out of the limestone shelf at the same temperature, flowing into the reservoir at the same steady rate whether the farm was owned by Walt Greer, the crop operation, the investment group, or Caleb Marsh. The pipe had always been there. The reservoir had always done its job. The HOA had always drunk from it. The only new thing was the line in the county records that formally said what had been happening for 22 years. The final scene was simple. Late in the afternoon of a dry September day, Caleb stood at the edge of the reservoir with his boots on the berm and the western sun low behind him. The intake pipe ran south from the reservoir toward the fence, crossed the line into the HOA's territory, and disappeared under the road. The meter on the HOA side clicked every few seconds, the sound of water moving through the system as it had moved for 22 years. The reservoir was 3/4 full, the water cool and clear, the surface reflecting the ridge above. He had come out to check the meter before the county's first fall inspection. The HOA had sent its maintenance crew earlier in the week, and the intake box was clean, the surrounding grass trimmed, the valve checked and locked again. The HOA's contractor had left a work log signed by Caleb at the top and the county inspector's signature at the bottom. The easement was working exactly as it was supposed to work. The water flowed, the farm farmed, the development drank. He crouched next to the intake box and looked at the pipe where it entered the reservoir. The connection was tight, the seal intact, the flow steady. He reached down and touched the water with his hand. It was cold, the way spring water always was at this time of year. He watched a small eddy pull across the surface toward the intake and vanish into the pipe. Behind him, the fields stretched silent, the soil resting between rotations. Ahead of him, the HOA's development sat just beyond the boundary, the road and the houses faint against the ridge. Somewhere on the other side of the pipe, water was running through faucets, filling bathtubs, filling irrigation lines for lawns that had never needed to know where the water came from until the day they did. He stood back up and walked along the berm toward the eastern edge. The spring came in from the limestone shelf, a steady seep no wider than his hand, feeding the reservoir inch by inch, not flashy, not dramatic, just constant. He had stood here with Walt Greer once, when he was 12 and the farm had belonged to Walt, and the spring had looked the same as it did now. Walt had said, "This water don't owe anybody nothing. It just runs. What you do with it is up to you." He had not understood that at 12. He understood it now. The HOA had used the spring without ever asking a lawyer. The board had assumed the notebook paper letter was enough. The county had approved the system without asking for a recorded easement. Caleb had bought the farm without knowing the HOA had been drinking from it. The spring had kept flowing through all of it. The only thing that had changed was the paper. The reservoir was his. The pipe was theirs under an easement. The water came from the spring, just as it always had. And the land it ran through had finally caught up with the record. He turned away from the reservoir and walked back toward the farmhouse, the dry country behind him, the spring behind him, the pipe in front of him, the development beyond the fence still drinking, still relying, now finally on something written down instead of something assumed. The spring ran through his land the way it always had. The story ended there, in the quiet, with the water moving where it always moved, and the record finally matching the truth.